morning, everyone. Good afternoon for those in the East Coast. Just a brief introduction. We'll briefly introduce ourselves. My name is Gladys V. Gervasio. I'm one of the immigration attorneys here in the LA office. I've been with the firm for almost 9 years. And today we'll be giving updates on immigration, and I'm joined by three guys. You want to introduce yourselves?
Okay, I'm Benjamin Fortuna. I work here from the Surgeon's office. I'm an immigration paralegal. I work with the team of Miss Sonia and Attorney Gladys. Thank you.
Juan, you want to go next?
Yeah, sure. Hello, everybody. Thank you for joining the call. Like Gladys mentioned, we're here to present on a few topics. I hope you enjoy. My name is Juan, and I've been with the firm. I'm a returning team member to the firm. I started in January 2020, so it's been roughly 7 months. So it's always a pleasure to be back.
Thank you, Juan. Sergio?
Hello, everyone. Thank you for joining. My name is Sergio Gonzalez. I'm a legal assistant here at the Edison office. I work with Dia Matthews, attorney here. So I've been here since 2018, actually, and it's been great. And I'm looking forward, working here and learning all I can.
Thank you, Sergio. So we have a lot of ground to cover. We'll be providing updates from the Department of State, USCIS, Department of Labor. So we'll just start with the presentation. So first, of course, is the presidential proclamation that suspends entry of certain HL&J non-immigrants. Of course, the purpose of this proclamation was to protect the local workforce so that they won't have to compete. Well, that was the intention, so that they won't have to compete for jobs during this COVID-19. It was effective on June 24, and the termination date is on December 31, 2020. But there is a provision in the proclamation that it could still be extended. Who are impacted? So those would be the HLJ non-immigrants who were outside the U.S. on June 24 without a valid visa. So those who were in the U.S. on June 24 are not covered by the proclamation. The others that are exempt are the H1B ones for Singaporean and Chilean, other non-immigrants such as TN, the P's, the O's, the R's. Those are not covered by the proclamation. And they did say those that would provide labor that's essential to the U.S. food supply chain, and those in the national interest, we'll discuss that more later on, are also exempt. Okay, so the question is, what if the H1B employee was in the U.S. on June 24? So again, that H1B employee would not be covered by the proclamation. The other question is, if the H1B principal was in the U.S. on June 24, but the H4 spouse and dependents were outside of the U.S. on June 24, can they apply for visas? And the Department of State clarified this on their website and said that yes, they can apply for their H4 visas, and the purpose is to promote family unity. Okay, what criteria will determine whether or not our client's entry would be in the national interest? So they said that if you're critical to the defense, law enforcement, or national security, if you're involved with providing medical care to those who have contracted COVID and are currently hospitalized, if you're providing medical research for COVID and necessary to facilitate economic recovery, and those that are aging out, that the posts are still denying outright these applications, and the reason for that is because they have not, the consular officers have not received guidance on the actual criteria on what would, be considered in the national interest. So that's the latest on that one. What about the impact of the proclamation on Canadian citizens? So because these Canadian citizens do not require a visa, the HLJ non-immigrants are not covered by the proclamation and can seek admission to the U.S. at the port of entry and be allowed to enter. The next question is, has CBP provided any guidance whether ESTA registration is the same as having a valid travel document?
Regarding the ESTA, registration is the same and valid, but they cannot travel at this time according to the ESTA website. If they do seek to travel, they'll lose the ESTA registration and they will not be refunded. And they would also have to get a B1, B2 in the future. So be very careful when you're guiding these individuals. We've had several that wanted to enter, but they cannot enter on the ESTA right now. And the ESTA website is very clear.
Okay, thank you, Sonia. And then one of the more concerning provisions of this proclamation is Section 5 that mandated the Secretaries of Labor and Homeland Security to take appropriate action to ensure that the presence of, EB2, EB3 immigrants would not disadvantage U.S. workers. And so what does this provision mean? There are speculations that they may require another labor certification process, but again, those are just speculations, and we'll provide updates once we get more information about this provision. Okay, let's move to the second proclamation. Juan, do you want to discuss this?
So absolutely. So what we have to consider and always remember is, where does this come from? What is happening right now in the climate? And if you really look closely and you really try to recap what has happened in the past year, these are probably extensions of what happened on the travel ban in December. And, it's just a way for the president to sort of make a proclamation, if you want to call it that way, and establish certain rules and new regulations for visa issuances. So for this one here specifically, this is the first one, and April 23rd, that's when he signed it, and it became effective at midnight of the next day, or actually 11:59 p.m. on the 23rd of April 2020. So what this one does is that it basically stops the processing of immigrant visas at the consulate. So they're no longer adjudicating or processing any new visas. So if you have happened to have an interview prior to April 23rd and you were successfully granted the visa as an immigrant, you could still come and enter the U.S. with that. If your interview was, however, on the 24th, you wouldn't actually be able to enter or use any. As a matter of fact, maybe there wasn't even an interview, at that point after April. So what it's really all about is how many visas are there going to be issued, and what are the numbers, and then for how long. So this proclamation is going to be established until December, at the end of this year. December 31st, 2020, as some of the team members have talked about and Gladys has just mentioned at the moment. So it might be renewed. We don't know. There's also, communications that had happened after the 152 proclamation that said, and we are also going to meet, Department of Labor, DHS, and, the president are going to meet and discuss, what are the numbers, what are they looking at in the future, so every couple of months, there might be changes coming back again, adjusting or modifying things in the proclamation. But if not, we can just go to the next slide and we'll talk about a few cases. So if the individual is in a possession of an immigrant visa that was received after an application interview at a U.S. consulate, but was unable to travel to the U.S. due to the travel restrictions or other exigencies, is she or he now prohibited from entering the U.S.? So again, let's just throw an example. You had to have an interview at the U.S. consulate between November 2019 and April 23rd, because that's 6 months approximately. So if you had an interview within that period of time, that means that you already went and sought the approval of the consulate to enter the U.S. So at that point, you were issued a visa to come in the U.S. But what happens if for some reason, like you are about to, because those visas are for 6 months, depending on the category, but at least the one that I'm familiar with, which is the family-based IR5 category for parents of U.S. citizens. At least for that one, you go to an interview, they give you a visa to enter the U.S. after the interview if you're successfully approved, and you can enter the U.S. in 6 months after your interview. So having said that, let's say April 23rd comes and you had a visa that was valid to enter on April 23rd or even April 24th, 2020. Could you still use it? Yes, you could use it because it's still valid. You enter the U.S. and once you're in the U.S., then you proceed and do, I think it's a second application that you do through USCIS so that you can get the actual card. But yeah, so after that, you come to the U.S. and nothing happened. Okay, will the immigrant visa issue but not used before April the 23rd? No, the answer is no. Why? Because when your visa is revoked, is because there's something happened. There's something that happened, that's really bad. So this proclamation is really out of your control. You can't really get a visa revoked because you didn't use your visa before the April 23rd. So it's more on the internal decision making on the consulate, and they won't revoke the visa. Yeah. And can an applicant for adjustment of status who has been temporarily absent from the U.S. on April the 23rd, 2020, while in possession of an advance parole travel document? Yes. The answer is yes. Because you're exempt. This proclamation doesn't apply to you. You have a valid travel document that you can use. Of course, it's going to be hard to get an interview at the consulate. I know there's some restrictions, and right now they're only taking emergency appointments. In this case, because you have a travel document, doesn't really apply to you, and you can just always use it and come back. Can you file? Yes, you can. You can file any cases. Of course, this is going through USCIS. Now, what happens is, when it's time for you to go to the consulate, that's when the time is going to be prolonged because there's no appointments really, at least at the end of the year. So after that, it is going to be a matter of time. I don't know, maybe applicants, as I think we'll talk a little bit about in the next slide. So yes, definitely, you can still apply. And this is just even going back to the question on the 152 proclamation, where there was an individual on an H1B valid visa, but his relatives or her relatives were in a foreign country. They can still apply, but there's not going to be a consulate appointment in the near future, or not at least until December 31st, 2020.
August 2020 visa bulletin. What about fiancé visas? Are the consulates accepting applications for fiancé visa, Juan or Benjamin?
Yes. I think there are 2 U.S. consulates, and these are the U.S. Embassy in Manila and in London. These have confirmed on their website that K visas are not impacted by the presidential proclamation. But for other consulates, we recommend that you check their websites.
Okay, so this brings us to the next topic, the visa bulletin. What is the reasoning behind this? Well, as Kirti explained, obviously there's more number of visa available to your home country if your home country is in the list. So, for instance, we see that in China for an EB1, in advance for 6 months. So what that means is, as of now, there's more visa available for these people because there were not enough people applying or getting the visa at that time. So that's what exactly it means. It really just says that right now there's a lot more slots open for those that want to apply for these visa categories. And what's the reasoning, or why is this advancing as opposed to retrogressing? It's still a question. There's debate, or there are sayings that it could be because maybe the applicants didn't have enough documents at the time and they didn't show up to the interview. It could be because of COVID. Maybe I had all my packet together, but all of a sudden COVID hit in and I'm unable to go and take care of my visa. So of course there's going to be more numbers. Industries as well, they had a swap, so you have no time in the wait time anymore because of all of the industries have switched. But that's basically what it means. And I know there's probably questions on that, and again, there's not an actually definite answer on this. And as we have actually talked in the presentation, what we know is that at the very least, Department of Labor and DHS, they're all kind of navigating what are the situations, what are the numbers, what are going to be the numbers in the future, whether they should issue more numbers open and available to the applicants or whether they should cut them.
Because of the suspension, then there are more visas available, and that explains the movement really, and that they're expecting more I-485 applications, but then the furlough, USCIS furlough will definitely affect adjudication of those cases. So let's move on. We have a lot of other topics to cover. So let's see. Thank you, Juan. Sergio, can you tell us more about this IT? We're now going to USCIS updates. So Sergio, can you tell us more about the IT Serve settlement agreement and the USCIS rescission of the Neufeld memo and the itineraries memo?
Sure, guys. Thank you. So IT Serve Alliance is it's a big organization that pretty much it has members ranging from all these consulting and IT service companies, and this recent ruling that so they had rescinded two memorandums. So the start of the Trump administration, USCIS started being more strict on on the policies designed around the H1B petitions. So throughout the period, the highest number. So throughout the period, there've been more like RFEs regarding employer-employee relationship and numerous other topics that they bring up in the notices that they request information on. So in particular, they've been denying petitions on behalf of mostly on information technology workers and accounting positions. So in response to this, IT Server Alliance, they brought up a lawsuit against USCIS, and they had argued that they've been violating the laws brought up on INS during the INS era, immigration naturalization services, and whenever so with their own guidance, they applied new versions of the employer-employee requirements to these IT consulting firms. And so according to the court, in 2003, USCIS initially adopted pre-existing and long-standing INS guidance memos, but more recently, during the Trump administration, it superseded a lot of these guidances, and with its own guidance memos without issuing regulations throughout these rule-making processes. So the case with IT Server Alliance and CISNA. So, federal judge strongly disagreed, pointing out the opinion that CIS has selected H-1B visa petitions from IT consulting businesses for special treatment with the effect of dramatically slowing the process of such visa petitions and reduce the accessibility by U.S. employers to such workers. So there's the challenges to the current policy. So so the court pretty much, to summarize, court pretty much found in favor of IT server lines on all the 3 points. For IT server lines specifically challenged CIS's current interpretation and application of the 3 different criteria currently required to receive an H-1B visa, which is the revised employer-employee relationship requirement. In particular, the definition of employer and the non-speculative work requirement to show non-speculative work assignments for the entire length of the requested visa, and the newly interpreted itinerary requiring that petitions include a detailed itinerary. So, as the bullet point says, the employer-employee relationship can be established by meeting only one of the following: hire, pay, fire, supervise, or otherwise control the work of factor under the following. So the first issue that the court found that the limited meaning of employer-employee relationship as announced and implemented by the CIS 2018 policy memo, it's inconsistent with longstanding INS 1991 regulation because it required formal rulemaking and cannot be upheld. Thus, the court stated that the combination of the CIS 2018 policy memo and the CIS 2010 guidance memo, to which the former gave strict and required reading, it destroys any discretion left to CIS adjudicators and renders the 2010 guidance memo similarly invalid as applied to plaintiffs. So, as a result, USCIS is bound to apply the meaning of employer-employee relationship as defined in the INS 1991 regulation and cannot add standards to evaluate an employer-employee relationship and deny visa petitions for failing to demonstrate an adequate employee relationship based on these additional standards. So, another.
So, Sergio, I have a question.
Go ahead.
Why is this such good news for our clients? The rescission of those 2 memos.
It's actually good news for me too, since I've been seeing all these RFEs brought up with employer-employee relationship. Most importantly, availability of work. We would be issued, say, you submit the H-1B petition to prove that there's a employer-employee relationship and specifically availability of work. Maybe we would submit whatever the petitioner gave us, let's say like a really short SOW, that's maybe 6 months long. But now I've been seeing that we haven't been receiving those anymore. And due to, this favorable outcome from IT Server Alliance versus CISNA. So the other thing is now I see that, we need to have a bona fide job offer for specialty occupation positions at the time of the filing. Employee-employee relationship and all these other, the new guidance that was issued. So you will now need evidence of day-to-day assignments, and they're not required but may help establish that the position offered is a specialty occupation. So USCIS may deny a H-1B petition if the petitioner has not established that the petition is in a specialty occupation. So benching of H-1B workers is still prohibited by law. USCIS may issue a NOID or NOIR for failure to maintain the beneficiary's H1B immigrant status, even if the beneficiary is paid while in a non-productive status, example benched. This may count as a material change, and thus it can still affect their status. USCIS can use their discretion to deny a change of status or extension of state requests for subsequent H1B filings after benching. So this may approve the new employment or amended H1B employment for consular processing. USCIS may issue H1B approvals for a shorter time period than requested on the H1B validity period, and they must provide an explanation as to why the validity period has been shortened. So your approval notice will be accompanied by a notice saying there's a limited validity approval for this. So it has to be exactly 365 days. So it won't be October 1st, 2020 to October 1st, 2023. It'll be 1 day before for the end validity date. So yeah, we expect further delays in these case adjudications.
USCIS currently has reduced capacity to print secure documents, including the lawful permanent resident cards, this is known the green cards, and employment authorization documents, also known as the AD cards. This lowered capacity comes after USCIS ended its contract with a third-party printing company in June 2020. So a hiring freeze has also decreased the agency's ability to meet the demand for card printing. USCIS, I think expects that this printing delay will continue for the foreseeable future. If individuals whose applications have been approved but has not yet received their cards must first try to resolve the issue with USCIS. And if USCIS cannot provide that solution, these individuals can send a case assistance request to the Office of Citizenship and Immigration Service Ombudsman after. Another one is the LPRs can request a stamp of temporary evidence for their passport that shows proof of their status by calling USCIS contact center at 1-800-375-5283 and make an appointment at their local USCIS field office.
Okay, so what about the status of current F students and those that are new or initial students? Can you tell us more about that?
Okay, this federal guidance was actually released by the ICE last March 2020, and this policy is about non-immigrant F1 students and M1 students attending schools operating entirely online may not take a full online courses load and remain in the United States. The U.S. Department of State will not issue visas to students enrolled in schools and or programs that are fully online for the fall semester, nor will U.S. Customs and Border Protection permit these students to enter the United States. So active students currently in the U.S. enrolled in such program must depart the country or take other measures such as transferring to a school with in-person instruction to remain in lawful status. If not, they may face immigration consequences, including but not limited to the initiation of removal proceedings. So the Department of Homeland Security has rescinded this recently announced policy that would have caused F student visa and M1 student visa holders to lose their valid non-immigrant status if they were enrolled in fully online courses for the fall 2020 semester. So after the challenges from Harvard, MIT, and the state of California, among others, the U.S. government is reversing this policy. This means that the F and M student visa holders may remain in the U.S. for their studies on valid non-immigrant status if their classes are fully online. So many universities have moved to online learning to help contain the spread of the coronavirus pandemic. Now, this rescinded policy guidance would have forced existing F1 students to either transfer to universities with in-person classes or to leave the country if their university had switched to fully online courses. There is a latest policy that came out yesterday. This announcement it follows this really a back and forth changes in the SEVP online learning policy, and most important points there is the new or initial students attending schools that are operating entirely online will not be permitted to enter the US or change to student status in order to make a full online course load for the fall 2020 semester. The only existing students who were in active service status on March 9 and who have been maintaining their lawful status since the date may continue their studies or obtain F1 visas and enter the US regardless of the school instruction format.
So Benjamin, just to clarify, if you're a new F1 student and you received your I-20 after March 9, 2020, and now the school just offers fully online classes, then you would not be able to get a visa and enter the US. Is that right?
Yes, that's correct. Yeah.
Okay. So yeah, we're almost out of time. Let's just quickly go through the other
extensions.
extensions.
Okay. But USCIS further extends this deadline flexibility in submitting delayed responses to requests for evidence and notices. So USCIS gave the applicants and petitioners additional 60 days for those issued between March 1 and September 11. Next slide, please. Okay, for this ICE extension on Form 9 remote verification until August 9, this announcement, this Form 9 remote verification came out last March 20, that DHS will exercise discretion to defer the physical presence requirements associated with the Form I-9 under Section 274A of the Immigration and Nationality Act. So employers with employees taking physical proximity precautions due to COVID-19 will not be required to review the employee's identity and employment authorization documents in the employee's physical presence. So this temporary flexibility only applies to the employers and workplace that are working remotely due to the COVID-19 pandemic. So how do you do it remotely is by the fax, by email, or over video link. And this also policy does not apply to the employers who have employees physically present at that work location. And these employers must still follow the physical presence requirement. Okay, next slide, please. The Mexico-Canada border closure is extended until August 20. I think the background of this one is there's a joint initiative between the United States and Canada, and also the US and Mexico, temporarily restricting all the non-essential travel across its borders. And this, I think, restriction began in March 21st, 2020, to contain the spread of the coronavirus pandemic. So DHS recently announced these restrictions as extended on August 20 for all non-essential land travel and ferry travel across the United States borders with Mexico and Canada. And while the tourism and recreational travel is not permitted, the essential travel like work, education, medical, and certain supply chains are still allowed. So we can see that this border closure may again be extended depending on the status of the COVID-19 emergency.
Okay, thank you, Benjamin. Before we move on to DOL updates, I guess other USCIS updates are, they're started issuing biometrics appointment notices, and the ASCs have been getting biometrics of the applicants, and the naturalization services have resumed. I see photos on Facebook, the USCIS account, and they're showing that oath ceremonies are done like in open parking areas. So just quickly on DOL, we have 3 minutes left. So they'll continue to issue electronic perm labor certifications until September 30, and they announced the 60-day public comment period on the proposed revisions to the perm. So let me just show you what the new form looks like. So let me see. There are now appendices A to D. The foreign worker information would be on Appendix A, and then additional worksite information would be on Appendix B. But look at this section. You see how they have more questions on the area of intended employment. And then also, I think the more notable ones are the questions on the notice of posting, whether you did it through physical or electronic, and whether you posted in in-house media. So they're specific now on that one. What other changes do we see? So it's a shorter version. So they said the reason why they're separating the employee information is that so the users can easily reuse the form when you fill it out. And then the other change is this one. The certification would now be a 2-page certification once the perm is approved. So this is how it would look. Yeah. So this is the 2-page perm employment certification approval. Okay, so they're not sending out the entire application anymore. Let me go back to the other one just to show it to you. Yes, so this is how the perm looks, the form. It doesn't contain the job duties anymore. So they said the information that we put in the prevailing wage, that would not be duplicated in the new form. So, but there's more information on the work site that you can see here. And then other notable changes are here on the post notice of posting. You see, you have to tick the box whether you did physical notice or electronic notice and in-house media. So they're more specific on that. But yeah, so it's still in the comments, public comment period, and that's expected to end in September 18. Thank you everyone for joining this session.